Hello, ladies and gentlemen. Ozzy Martinez here with the Semper Ozzy Show. We're going to talk today about a lot of stuff, but we're going to clear a lot of confusion up, right? Because there's a lot of confusion of this current topic that we're going to talk about right now, and it involves previous cases as well and stuff like that service members like myself and Ed have. For instance, more recently, there's been the 3M lawsuit that is involved with the hearing protection that we used while we were out in overseas in Iraq and Afghanistan. Even more recently, there's been the burn pit situation going on that I also fall under. Now what we're here for and to talk about, all right, is the Camp LeJeune Justice Act.
Right.
What differs between the three of them that makes the Camp LeJeune Justice Act different than the burn pit and the 3M?
Okay, so before I jump in, just that way all of your listeners know that I have a little bit of street cred, I want to tell you a little bit about where I'm from, because it's been a while since I've been on the podcast. So me and Sarah and Ed are all from Rubenstein Law. Sarah and I are partners there. Rubenstein Law is a Florida-based law firm where we handle personal injury matters, car accidents, slip and falls, medical malpractice, and we have a very big mass tort department now. We're handling cases like the one you mentioned, the 3M. We are handling the Camp LeJeune cases. So we're very involved in the community, in the veteran community, and trying to get people information is what we've noticed is the most important thing. Our firm is made up of 50 attorneys spread out over 15 offices with 9 board certified attorneys. So our goal today is to clear up exactly that, Ozzy. Like any confusion that exists, any questions that we have, I hope that we can help you guys and help everybody understand what rights you have, what avenues for, justice you have, and how best to deal with it. But to answer your question, okay, I will say, here's the thing. The 3M lawsuits differ from, let's start with 3M. They differ from Camp LeJeune because the Camp LeJeune lawsuits, and we'll give you guys background in a few minutes, but the Camp LeJeune lawsuits, the defendant, the person that's being sued, is the federal government, okay? 3M was the company being sued by the veterans. So it's a private company versus the federal government. Those two lawsuits are different, all right? The burn pit is not a lawsuit. Now, it was passed, the legislation that allowed for veterans to receive disability benefits if they were exposed for, they have an injury because of an exposure to the burn pits. That was passed in the same legislation where the Camp LeJeune Justice Act was passed, right? So people think, okay, great, that's the same type of case, but it's not. For the Camp LeJeune victims, they've had an avenue for years to seek disability benefits, but they've never had and that only applies to the veterans. But the other family members that were affected by this, because people were living on base and drinking this contaminated water, they've never had an avenue for justice. Now, with burn pit, it's different. It's our service members, it's our veterans, it's our current military that were exposed to this. And so now they have an avenue, although it's not through suing the federal government in a civil action, but through being able to seek those disability benefits that they weren't able to seek before. Does that make sense?
Yes, it does.
Okay.
So this brings me to my next question, because I remember I'm what we call an East Coast Marine. You have West Coast Marines and East Coast Marines. Usually the way that's split up is if you live on the east of the Mississippi River, you're an East Coast Marine. You go to Parris Island, South Carolina for boot camp. Right after that, you go to Camp LeJeune for, and my generation is now MCT, Marine Combat Training in the School of Infantry, SOI. When did contamination begin? Because I remember when I first heard about this, I think I texted you or something, and I was like, hey, do I qualify for this or something like that? Because I remember being there, but I clearly don't. So can you answer that for us, sir?
Absolutely. And let me introduce myself too. I work with Miriam at Rubenstein Law, Sarah Vega, and we are the two partners that oversee our mass tort department. So we're very involved with the Camp LeJeune Justice Act and the Camp LeJeune cases. And we get these questions every day. So we're happy to be here to kind of share the information. So the contamination was over a pretty long period of time. It started around August 1953 and lasted until December of 1987. So anyone that was on Camp LeJeune, whether you served there, your family member, or you worked there during that time period for a consecutive 30 days, you qualify if you suffered one of the illnesses that is being related to the water contamination.
Okay, and these illnesses are coming from the actual chemicals that were in the water, correct? And what chemicals were actually placed in the water?
Okay, so there's a slew of chemicals that were actually in the water, but there's 4 main chemicals that we are dealing with. And I will say some of the names are very difficult to pronounce. But I will say the abbreviations are TCE. That's one of the chemicals in there. Benzene was in the vinyl chloride was in there. And I think there's another one that is TCI, if I'm not mistaken, that was also in the water that was contaminating it. But if I can, I know you're probably going to ask this. It's kind of important to talk about how it is that this became contaminated and who was affected. So if we're looking at the way Camp LeJeune worked was that they have water plants. And so there are several water plants that hit different areas. Like and I learned this when we were researching this legislation. There were different areas where people lived. One of them was called Tarawa Terrace and Had Not Point. Those are very affected areas where we know for a fact that there was contaminated water. The water plants were contaminated through the soil. And they weren't being filtered out, they weren't being cleaned, and the federal government was not taking the appropriate measures to test the water like they should have.
And these are actual base housing locations you're talking about.
Absolutely.
So for
Correct.
individuals that were stationed there, their family members that lived on the base.
That's right. And any civilian employees, anybody who was there for a period of 30 days or more could have been affected.
Because people don't realize within a military base, it's almost like a micro city. We have everything. We have schools on base where kids can go there, and not necessarily the wives or husbands are teachers. So we have civilians that live out in town that come work on base. So that's where you bring it up that people might not know.
I think that's the biggest misconception
Correct.
is that they feel that they have to be a veteran or someone who served to have a claim. But that's what's amazing about this legislation and why it should have passed probably 15 years ago, 20, maybe 30 years ago, honestly, is the fact that now everybody who never had an avenue to seek justice. Everyone, civilians, family members. If you were a mother who was pregnant with a child, when that child was born, they developed certain issues. That child has rights. They have an ability now. This avenue to seek justice. That's what this legislation did.
So let me ask you, ladies, a question. Somebody in my scenario, because we're talking about the years that were there, and I'm trying to do the math in my head. It falls from veterans that are Ed's generation to then individuals like myself that was born in 1982. I could have been born in Camp LeJeune, right? So I fall into this. But now let's say now that this is all coming to me, this is all news to me, what are the actual illnesses that people experience? For instance, if my parents were stationed there and now I'm learning about this, maybe there's something that they had that is the reason why they had it. So what are the illnesses that people are experiencing or experienced with this?
Absolutely, and that's a great question because there are a few cancers and serious illnesses that have already been determined by the VA to be related to the water contamination, but there's so many more that we're still doing studies and still doing investigation to determine, there's several cancers that are related, and I could go through them all. And obviously, if anyone has questions or they think they might qualify, they should definitely reach out to Rubenstein Law. We're happy to look into their case. But there's leukemias, there's bladder cancer, there's non-Hodgkin's lymphoma, Parkinson's disease. There's so many, and Miriam could probably name some more that they've suffered.
Yeah, I mean, one that there's a lot of evidence that strongly links it is obviously the non-Hodgkin's lymphoma, which is awful. But there really is a long list of injuries, and I will tell you that the research is still very much alive with this. I'm assuming, Ed, can I bring Ed? Ed, I'm assuming, like for you, I guess I'm always kind of curious because you served during this time period. I mean, was there even a buzz, a question? Was anybody even concerned about their water at this point? I mean, what did you know about it from the perspective of someone who was actually serving near the area of Camp LeJeune?
Well, first of all, let me introduce myself to those that don't know me. I'm Ed Carrera. I'm with Rubenstein Law in the motorcycle division. We have a division which tends to motorcycle groups, and we work with a lot of the veteran motorcycle riders. So, getting back to your question, when I was there, and actually to preface that, I had heard about the Camp LeJeune issue, and I served in Camp Geiger. Everybody that went through Paris Island for the basic training then went to Camp Geiger, which is a suburb, for lack of a better word, of Camp LeJeune. So the other thing that was obvious too when I heard about this was a lot of my guys in my age group are no longer with us. So to find out that now the families who were there with them, stationed in Camp LeJeune, and their offspring, which could very well be affected, now they have an avenue to seek some kind of help.
Absolutely.
But no, when we were there, we're in training. You wake up and go work out, train, and come back and you drink water and eat the food and don't think anything of it.
We have heard from some of our clients that there was a unique taste and smell to the water that they had complained about that was very different. Which I think was a slight indication that there was something amiss.
And people need to understand that this is a long time ago where this bottled water wasn't easily accessible,
Right.
didn't exist the way it does now. So to give people, at least for not the civilians that were showering with this, drinking the water from the faucet in their homes, so that they understand when we're out in the field, we have these big trailers that are potable water or water that we could drink. And it's always make a line, fill up your canteen, and drink.
Right.
And they were called water buffaloes.
Right.
When I was there. So it having a taste was normal.
Right.
All right. So I have a question because we did bring this up, and I think we've touched it. But Ed brought it up, and I do want to clear this out. This does affect pregnant mothers as well. It would affect the baby,
Right,
through
if it did.
a utero, correct?
In utero, yeah. So it's basically when a mother is pregnant with a child, that child is in utero. That's what the medical terminology for it is. And so if that child, when born, turns out that they develop some neurobehavioral defects, certain illnesses, then that child may have their own individual claim. Now, Ed, you mentioned something that is really important, which is that a lot of the people who served during this time period who were exposed to this contaminated water, that they've passed on.
Right.
I think it's important to mention because the distinction, I feel like sometimes it's hard to talk about the big distinction between a disability benefit and a civil action, but a civil action also covers a wrongful death. So the families even if those families are perfectly healthy, if their loved one died because of a qualifying injury, which we are happy to discuss with you guys if anybody wants to call our office, then they also have a claim for that loved one, which they should pursue.
That brings me to my next question, which is now makes me think, as a disabled vet, I already get benefits. In a situation like that, where a service member, let's say, had already gotten benefits, maybe for some of the symptoms or the disabilities that you get from this, has passed or not, can the family still now sue even though they did get benefits at one point in time?
Yes, the family can still sue. I think go ahead.
Absolutely. And I had something else that I want to respond to your other question, but I'll answer this one first. Yeah, of course, the family can sue. And, that's the main question a lot of our clients are asking when they call in. Is this going to affect my benefits? If my loved one received benefits, does that limit our opportunity? They're separate. So like Miriam said, the civil cause of action still exists. If you did receive any type of benefits for the illnesses that you suffered from Camp LeJeune that we're going to claim in the cause of action, the civil lawsuit, then there might be a right to subrogation, an offset for those benefits. You might have to pay the government back for those benefits, but it doesn't eliminate your right to proceed, and it doesn't, you won't lose your future benefits, which a lot of service members are concerned about when they call us.
If I can add something to that,
absolutely.
When we talk about a subrogation right, though, and paying back the government, it's only paying them from proceeds that you haven't technically received yet. So what that means is it's not like they're going to go into your bank account and take money out, but typically before the money is even, the settlement monies or the trial money is dispersed to you, the person winning that award, basically it's like the federal government puts a lien on a certain amount of that.
So they get it before we even receive it.
Right. But that's important because one of the questions that we get constantly is, am I going to lose my benefits? Am I going to have to pay something back?
I mean, of course. I've been overpaid. I've been overpaid by the VA for education benefits or disability benefits, and they will garnish my paycheck for the next few months. You know, since I'm disabled, they'll say $50 a month for 2 years.
Right.
But that's $50 a month you're losing. So you're saying, though, that they'll go ahead and that's all done beforehand, so you don't have to worry about the headaches of
it only attaches, right, like Miriam said, to a recovery or a settlement. It has nothing to do unless you receive a recovery or a settlement. Right.
So the prerequisite is to first get a hopefully big award from the government before any amount of that is taken out for what is known as that subrogation right that the government has because of the disability benefits. But I want the message to be clear that veterans who are receiving compensation for disability benefits, you're not going to lose those benefits. And also, something people should know is, yes, we're attorneys handling the Camp LeJeune cases, but we're multifaceted. We're happy to explore all angles of this. Anything that, that there are questions about that we need to answer, this is the time to ask. You have someone who's going to sit there and answer. Better to call and ask than to avoid calling because you don't want to get, you're not sure, Absolutely. You don't want to risk it. Call and ask. It's worth it.
If I may interject,
Absolutely.
I think it's a here we are, two different time groups having totally different issues with the same problem.
Right.
And I think, at least for my age group, it's very important for us to get the word out to the families because a lot of the people have passed away or are disabled and cannot, call and do this for themselves. So it would be on the family to do that, to be able to file that claim.
You know what, Ed? I'm glad you brought that up because that brings me to like a more personal now level. This is a question that I think we never even brought up in discussion, but the way that you just mentioned that has now made me feel very personal about this. Us veterans have a pride issue. We don't want to sue. We don't want to go after. We don't even want to get our own benefits. Right. So you brought up the whole difference in generation. And us younger veterans learn a lot from older veterans all the time. What would you say to an individual that's listening that has that hard mindset like me right now, but like how you said, you've already seen the aftermath. You've already had your brothers die. What do you say to the people that don't want to try to go after it or not? Do you encourage them, like how Miriam said, please call us?
Well, from a personal point, and I'm sure you share this feeling, Marines would never do anything against the Marine Corps. So it's hard for us to think that the Marine Corps would do something, that would injure us purposely. So we have to step back and say it's not the Marine Corps that we love and would never do anything against. It's somebody that was uncaring, that knew that the water was contaminated and never did anything about it. So you have to get past that point to be able to do that and to take action. Otherwise, you feel like you're betraying your own heart, something you love.
Yeah.
So.
Can I add something to that? From a civilian perspective, but you guys know I was raised by a police officer, by people who serve this nation, and one thing that I think is important, and I have the same fights with my father, my husband, who's a veteran and a cop, but what you guys did, your service was to protect the rights that you now have. So why would everybody else be able to take advantage of those rights that you fought and put your life on the line to protect and not you?
Guys.
And that's why I brought that question up, because I wanted that question to be asked by my generation like that, because we're now that generation that might be going through that 3M lawsuit and saying we don't want to, right? But we got to hear what his generation went through, right?
Right.
So then we could say, you know what? You have the ability to fight for it now and get it. You have to do it, right? Because if not, then now we end up losing.
Right.
Yeah.
Huge. So that leads me, go ahead, I'm sorry.
No, I wanted to, I know we've kind of gone off on a tangent, but when you were talking about whether if you were in utero, if you were born on Camp LeJeune, if you have a right to recovery too, one of the illnesses that I failed to mention earlier when you asked me the question was a lot of women who were on the base, whether they served or whether they were family members, suffered from infertility and miscarriage. And we're getting a lot of clients that suffered those types of injuries from the water contamination as well. So I just wanted to mention that. But I know you were leading to your next question.
So actually, no, that one's good because we could retouch that a little bit more. Let's just say I was born, like I said, in '82. I was affected by this, and I started, my family treated me as a child for some sort of a cancer or something, and now I'm clear from that. Can we still, as well, with my medical record, go through and go back and try to not recover, but somewhat right the wrongs?
Absolutely. Yes, recover. If you qualify, you were on base during that time period, you suffered from the water contamination, and were diagnosed with a cancer. If you're in remission and you've been recovered from it now, you can still recover for that injury. Absolutely.
And I want people to understand, like I said, when we paint this picture, it's so you to understand that anybody, if you were working, a civilian out in town, you were a teacher in that school that's there,
Yep.
your child could be affected,
Right.
even though, because you were pregnant with that child.
Worked in a restaurant there, worked on base, passed through, but for a sufficient amount of time, absolutely.
And we had people who maybe lived in New River, but worked in Camp LeJeune. They qualify because it's any exposure to that water. I'm sorry, Ed.
No. What I was going to say was one of the questions that I had. Everybody that went through Paris Island automatically went to Camp Geiger. And my biggest question is, us guys that went through Camp Geiger, is that part of this suit, or was that a different water source for Camp Geiger than for Camp LeJeune? Because everybody that was a recruit that went through Paris Island would have gone and spent a considerable amount of time in Camp Geiger for infantry training.
Yeah, so I've answered this question in the past, and I'll tell you, the Agency for Toxic Substances and Disease Registry, which is a federal agency that was charged with investigating the Camp Lejeune water contamination, they've clearly come out and said that Camp Geiger and New River were not exposed to the contaminated water. But one thing that's interesting about litigation and these types of cases is they're moving, they're fluid. There's no black and white rule. And that's why we always encourage call, because you don't know. But it's important to note, the VA, right, when they're giving out their disability benefits for people affected by the Camp Lejeune water contamination, they do include Camp Geiger
They do
and New River.
recognize.
So they recognize it. But from the evidence that is shown from the Agency for Toxic Substances and Disease Registry, which is part of the CDC, they don't recognize it.
Now, as a legal terminology I've been hearing and stuff, does that not show precedent? Or like some sort that if the U.S. government is claiming or recognizing it as a claim, that this can help out some sort of way?
Yeah,
or?
so go ahead.
I was going to say, it depends on the burden of proof, right?
Okay.
The burden of proof for a disability claim is different than the burden of proof for a civil action. And in civil actions, the burden of proof tends to be higher. So I certainly think it's good evidence. And so, my immediate answer is to say, I don't think those folks in Camp Geiger or New River were automatically exposed to the water. But at this point, learning everything that we're learning, I think it's worth it to give us a call. If you live there, you have a qualifying injury, or if you lived in Camp Geiger or New River, it might be worth it to give us a call and have that conversation. Let's see what those injuries are, and let's see how the litigation plays out. Absolutely. Because what you wouldn't want to do, and I'm sorry, I feel like
it's okay.
I'm like bogarting
I'll
the
jump in.
conversation. But what you wouldn't want to do is wait so long. The one downside to this legislation is that it only gives us 2 years from the date it passed to get your claim filed. 2 years. That's all we have. And
When did it pass?
August
10th of
this
this
year.
year,
It just
2022.
passed. It just passed. But I know you guys have mentioned, some of your fellow service members are hesitant. It's always better to call and find out and answer your questions. And to add on to what Miriam said, and I do think she's right. I think the points of contamination, water contamination, the water plants, the dry cleaners was all in Camp Lejeune, but it's still early. The litigation is fluid. We're still looking into it, and it is possible that whether you are at New River, Camp Geiger, the rifle base, that there could have been some sources of water contamination that spread that far, or maybe you passed through Camp Lejeune. So we're looking into all of it, and it's worth giving us a call.
I mean, at any point in time, those water mules that you talked about could have been filled up in Camp Lejeune and
Absolutely.
brought out to Camp Geiger.
Right.
Absolutely.
Right.
And,
So that leads me to my following questions that we're going to wrap this up with, though. But what should you do if you think you have a claim? Should you hire an attorney now or wait? Or because you said you have that 2 years, so what should you do?
Hire an attorney now.
Absolutely do not wait. I mean, I think time is not on your side here.
Yeah.
It makes sense to give us a call because with the government, with the law that was passed, you have 2 years. You have to file a notice of claim first, which is already another deadline that we have to file. So, we have to nothing is fast with the federal government, unfortunately. We have to get your records, we have to prove up the case, and so it's better to call now to see if you qualify and start building the case.
So we got 2 years to go ahead and file. How long does a litigation like this usually take?
It can last a few years. I mean, we know that there's some litigation out there that's gone on for 8 years. There's still opioid cases. I'm sure everyone's heard of those. So it can last. It's hard to predict that, Ozzy, but I would probably say anywhere between 4 to 6 years by the time that the litigation is fully concluded. That's my guesstimate.
Okay.
Yeah, I think, the consensus is pretty much they're probably not going to start resolving cases or settling claims until they know how many are out there. So probably within the 2 years is when they're going to decide how many people are bringing claims, what are the injuries everyone's claiming. And I think at that point, they're going to assess and decide kind of the direction of the litigation.
And one of the things, if I might interject, is getting it started. Because the sooner you get it started, the sooner you start that time period.
Right.
And just to clarify, we understand this, but people listening may not. When we say hire an attorney, there's no out-of-pocket cost for you. What we meant to say is call us, let us take a look at the case.
Absolutely.
And then there's no charge to you until you win the case.
I'm glad you bring that up, Ed. So there is no out-of-pocket expense, even if it does take 8 years,
That's
let's
right.
just say.
Yep.
Okay.
Yeah. That's
Yeah.
correct. There's no out-of-pocket expense for anybody who we represent. We work on what's known as a contingency fee, and obviously we can discuss that in detail if when they call. But one of the things, and Ed kind of triggered my memory with it, was the reason that you're not taking any out-of-pocket costs is because we're doing everything in our power to request all of the appropriate records. But before we can even file the administrative claim with the federal government, to then have the ability to file the case, which is the procedure, we need a certain amount of records. And some of those records are going to come from either VA doctors or private doctors that the client has gone to. And of course, the records showing the proof of either residency or service at the base. That's just like preliminary records that we need. So it's important for us to have the time to get that and to be able to file the strongest claim for each individual client.
And how does this work? Like, where do these cases get handled? Do I have to show up to the court? Does my family have to show up?
We're dragging you with us.
You specifically, yes, we're taking you. No, all of these cases have to be filed in federal court in North Carolina. So that's where they ultimately will be filed. Obviously, we have to file the notice of claim first. But we don't need to bring our clients with us normally in these types of cases. We need your participation to find out information, but we really try to do all the work, front all the costs, everything like that. So we just need to confirm that that our clients qualify, and then we do all the heavy lifting.
Okay, so I'm at the point right now, if I'm listening to this, and I know either I suffered with something at a younger age, or I'm older now and I know that my children suffered, or my spouse suffered, or something like that. I have made the decision that I do want to call, and I do want to hire an attorney. Where am I calling? How do I find you guys?
You can call 1-800-FL-LEGAL, or you can go on our website, rubensteinlaw.com. That's RUBENSTEIN law.com, to reach out to us.
And there is a landing page. I know that because I have seen it. That you could go to Rubenstein Law, and they have a whole entire Camp LeJeune landing page that you could go and get any more information that you need.
Absolutely. Right. You can see the injuries there. A lot of the questions that a lot of our clients have are answered there too, but we're happy to get on the phone with anyone and answer any additional questions they might have.
Now, there's not many that would qualify for something like this question, but it is something that I was curious about. If I'm currently within the 3M case, can I also file for this case as well? Or if there's any other previous case like that I'm associated with, can I also file for this case as well?
It's particular to your question about the injuries are very different. The cause of action is very different, correct? Okay. So, we do handle a lot of other mass torts, like Miriam explained at the beginning of this discussion. But we can't claim the same injury for different causes of action per se. But 3M earplugs is completely different from the Camp LeJeune water contamination.
Right. Just my train of thought, like how we asked before, are my benefits going to get affected? This and that. We've been so conditioned that everything is connected to your service or something like that. That if you go through this avenue, you're going to get taken from this avenue. So these are These are good questions to ask, so that we understand that how you've already brought up that our benefits are not going to get affected. You are not going to get taken from the left because we gave you on the right.
Right.
So.
Absolutely. Yeah.
Ed, do you have any more questions?
The 6 winning lotto numbers? Yeah.
Oh God, I wish.
I'll take those off so we can share, guys. Share.
All right. Well, I don't have any more questions. I think that we took a subject and we made it to where anybody can now understand and realize that anybody can be affected by this. It's not just the service member that served and was stationed there. If you passed through there, you worked there, you were born there, you can be affected and your family can be affected.
Absolutely. And I know we didn't mention all the injuries that you might have had, but if you have a serious injury, a cancer, anything, and you qualify like you just mentioned, it's worth giving us a call to find out more information.
One last thing, because I know I brought it up, but I forget, but I think it's the most important part is what are the years of service again? What are the years of
53 to
contamination?
87.
Yeah.
So 53 to 87. And I remember bringing this up in our meeting, discussing this interview, is how I brought it up. I was like, wow, that's a huge generation, because we're talking about veterans that could be easily in their 80s, throwing it max, and then young guys that were born in their 40s, or individuals that were born in their 40s. Yep. So it's a huge gap of people in between that can be affected.
Absolutely.
Yeah, that's why I was saying that a lot of the veterans have passed away or are disabled now, and it's good for their families to know that they're able to file for them, or if they were there with them, to file for themselves.
That's right.
But the important thing is, even if you have a question, I don't even know if I'm affected, call and ask.
Yeah, absolutely.
And say, hey, I was there, or we were there, or my father was there, and Rubenstein will take a look into it, and if the case has merit, they'll take care of it for you.
Yeah, it's a no-risk situation. You don't lose anything by placing a phone call.
Awesome. Well, ladies and gentlemen, thank you for joining us. I want to thank Rubenstein Law once again for coming on the show and explaining and answering our questions. Don't forget, reach out to them. I know Ed personally, we ride motorcycles together. So if you have any motorcycle injuries or accidents or anything like that, please call Ed for sure. And if there's any 3M or anything like that, please call these ladies, because I know they're highly educated on these subjects. If anybody has any questions, do not hesitate. Go to RubensteinLaw.com or call 1-800-FL-LEGAL, and they'll answer all your questions. Thank you and have a great day.
Thank you.
Thank you for having us.